We are recording.
Good morning, everyone. Welcome to the appellate court. I'm Judge Bright. I'm sitting this morning with Judge Elgo and Judge Abrams on the matter of Purnell versus the Inland Wetlands and Watercourses Commission of the Town of Washington, AC docket numbers 44083. This argument is being conducted over the Teams platform, so everyone is appearing by video conferencing. In addition, it's being streamed live over the branch's YouTube channel, and we post it to the branch's website later today. I would remind everybody that although this is a virtual hearing, it is the same as being in the courtroom, and we would ask everybody to conduct themselves as if they were in our physical courtroom here in Hartford. I'm going to ask everybody to introduce themselves just so we can make sure we can hear and see each other. I'll start with the judges, then counsel for the appellant, then counsel for the Inland Wetlands Commission, then counsel for the applicant. Again, I'm Judge Bright.
Morning, I'm Judge Elgo.
Good morning, I'm Judge Abrams.
Good morning, I'm Gail McTaggart, representing the appellants.
Good morning, I'm Carrie Olson, representing the Washington Inland Wetlands and Watercourses Commission.
Good morning. I'm David Sherwood. I'm representing 101 Wickham Road, LLC, the applicant.
All right, I can hear and see everyone okay. I assume that's true for everyone else. If at any time you're unable to hear anyone, please let us know. If you're unable to see anyone, please let us know. If you get disconnected from the hearing for whatever reason, please log on through the link again. We will suspend the argument until we have everybody present. We are going to ask everyone to keep their microphones muted during the argument when you're not talking to avoid any background noises and any cross-talking. The judges will follow that as well. If we have questions, we will raise our hands and ask counsel to recognize us, again, to avoid talking over each other. If you don't, we'll just jump in like we would in the courtroom. I would ask, though, that you keep your cameras on at all times so we can make sure everyone's present and appropriately focused on the argument. Now, in this case, there were two appellees' briefs filed, so I don't know if the appellees have discussed how they intend to split their 20 minutes of argument.
David Sherwood for appellee 101 Wickham Road, Your Honor. Yes, we have. I will be taking 12 minutes of the argument, and for the Inland Wetlands Commission will be taking 8 with the court's permission.
All right. And you'll be going first, Attorney Sherwood?
Yes, Your Honor.
Okay, so you'll have 12 minutes. Attorney Olson will have 8 minutes. Attorney McTaggart, you'll have 20 minutes to argue. You can reserve some time for rebuttal. I will be keeping the time because we do not have our light system here. I will hold up signs at 2 minutes, at 1 minute, and when your time is up. So with that, I believe we're ready to proceed. Attorney McTaggart, you ready to go?
Yes, I am, Your Honor. First of all, I'd like to reserve 5 minutes at the end of my argument and take 15 minutes for the primary argument.
Sure, all set.
And for the record, I represent Marguerite Purnell, Connecticut Environmental Protection Act 22A, 19A intervener, and Matilda Giampietro, who is statutorily aggrieved neighbor to the Wickham project. And I'd like to start by saying that the history of this development is long and complicated, but what is before the court is not so complicated. It is, in our view, a new permit, which requires all of the scrutiny required and mandated by 22A-41A of the Inland Wetlands Act and also Section 1102 of the regulations. That mandate is as set forth in this court's decision in Starbo versus Inland Wetlands of the town of Hartford, and is where it finds that this kind of review is mandatory for all permits. It is evident that the trial court failed to appreciate the scope of this project and the sensitivity of this site as it applies to wetlands protection and what was applied for. Just inside the northern boundary is Kirby Brook, and Kirby Brook flows 1,150 linear feet along that boundary. It's a perennial cold water trout stream that feeds into the Chippewa River. It is an important wetlands resource. The brook has a high aquatic rating. It's based on a rapid bioassessment that is done by volunteer monitors for wadable streams and rivers, and it deserves protection. The application at issue is for construction of an inn and associated buildings, stormwater management utilities, drives. There is also going to be a resort type condominium complex proposed, public restaurants, separate bar lounges, 4,000 square feet of event space, pool, and year-round use. So it will be an active site. The development is planned will occur on steep slopes and moderately steep slopes that are up gradient from Kirby Brook. The vertical elevation range goes 178 feet from the northwest corner, which is right where the river flows out of the property, up to the southwest corner. So this is a sharp and steep grade. To get to the property requires 2 road crossings. The road crossings will come across the brook. Brook crossings. The brook crossings will cross over to the other side where there is proposed 110,261 square feet of impervious surfaces, which are buildings, pavings, drives, 100 parking spaces, and that runoff flows to 2 large stormwater ponds, which have been an important part of the application. One of the ponds, pond number 2, is located completely within the Kirby Brook 100-foot upland review area, and it drains to the brook. It has a footprint of 10,174 square feet, approximately 180 by 172. So it's about the size of 4 residential houses in footprint. Pond number 1 is sited between 2 fingers of wetlands and is also located in the upland review area of the western wetlands on the property, and it drains to wetlands that in turn drain to Kirby Brook. It has a footprint of 15,700 square feet, approximately 164 by 124. Judge Ebel?
Council, I was wondering if you could address to what extent you are able to distinguish this case with Bradley, because what I understand from that case was that they were dealing also with an expired permit, and the court below, if I'm correct, still used the substantial evidence of change despite the fact that there was an expiration. And I may not understand all of the issues here, but perhaps you could speak to that, because that was something I was trying to wrap my head around.
Yeah, nothing in Bradley would have prevented a robust and de novo type review of new information that came in on the application. And in Bradley, in fact, what the court did is the court denied the second application that came in, even though it had approved the earlier application. So that case actually, in some ways, supports this review that is happening here, where we're looking at a new application. It's not just about whether the application is identical, which in fact our briefs have shown that it certainly is not. But secondly, whether there are new facts, changes. One of the chairmen during deliberations of this commission indicated that there are 9 years with engineering changes and significant ways that these kinds of applications are reviewed that in fact are new information that should be considered. So I think Bradley in fact supports this decision. The application, the judge, the trial court found that the only activities were in the upland review area without looking at what the impact of that might have been on the Kirby Brook and the associated watercourses. But the application itself and the forms that are filled out that are required by the state DEP certifies that this site has wetlands, watercourses, and regulated activities. And regulated activities, as I think this court is aware, can be within upland review areas where there's a likelihood of impacting. In this case, regulated activities in Washington are defined as including storm drainage systems, excavation, and the kinds of massive stormwater facilities that are proposed in this application. I think it's important to also.
Attorney McTaggart,
Yes, Your Honor.
how did these ponds, these stormwater ponds, differ from stormwater ponds in the previous applications?
They're cited in the same area, but as pointed out by the commission's expert, Landtech, the requirements for the sizing and the capacity of those ponds and the infiltration of those ponds changes with the development changes that happen on the site. So this development that went from a development that had pervious surfaces planned in 2008 with swales, 26 rain gardens, lots of low impact development provisions, green roofs, all of that had affected what those stormwater basins do. Today, there is not only an increase in the main building by 8,000 square feet for the footprint, which translates to disturbance, but 13.7% of the site is going to be disturbed of a 26-acre site in order to accommodate this application. So the ponds are in the same location. Their function has to obviously be matched to the development.
So could I, if I could just ask this, and then I think Judge Abrams has a question. So are the ponds the same size as in earlier applications?
The ponds have been changed to add new entrances and exits, and the depth has been adjusted. There have been adjustments to the pond. It's just that the general location is the same.
Okay.
Thank you. If we find that the application does not contain significant changes from the old permit, are we compelled to affirm the trial court decision?
First of all, no, you are not, because that's not the correct standard to be applied here. This is a new application. It requires looking at all of the factors that are set out. It is not simply a renewal or a modification. The wetland statutes set out expirations of permits for a reason. And this one started in 2008, had the benefit of a modification to affordable housing application, had the benefit of another modification to a university, had the benefit of another university plan, had the benefit then of another modification that we call Pally House in 2014 and 2015, had other modifications. So stepwise, there were a number of modifications, each time looking to see if that modification was significant. But the sum total of those modifications ended up with a very different plan than in 2008. In 2008, the commission determined by a 5-0 vote that this application was a significant impact application and held a public hearing on that basis. In this case, the commission didn't ever classify it as a significant impact, started off by saying, what do we need to revise in the approval resolutions? Finally got a petition for a public hearing from 62 residents, and that's the reason that there was a public hearing. So the kind of review that would require for a modification is not available here. The state statutes set where a commission does look at substantial changes, and those are renewals of existing permits. there is no existing permit here. There comes a time after 11 years on a no-build project, particularly like this one, it's never been constructed. So there's nothing that saves it from a thorough and robust review. And certainly the Environmental Protection Act requires that kind of review.
With respect to the Environmental Protection Act, if the conclusion is that this will not have a significantly impair the natural resources, do you ever reach the feasible and prudent alternatives? Just under the Act, not under 22A42.
Yes, you do, because I believe the Starbull decision tells us that 22A42A1, I guess it's subparagraph 2, that requires the commission to look and see if there's something that would be a proposal that would have less impact than what is proposed is still applies. So I don't see how you avoid the feasible and prudent alternative analysis under our statutory scheme as it's been construed by this court. We believe that if this decision is allowed to stand, it completely undercuts the beneficial role of SEPA interveners. It also undercuts the purpose for public hearings in wetlands decision-making and allows the Wetlands Commission to disregard the statutory mandates and the regulations for the protection of wetlands. There is a really serious question about what the point is of having a participating SEPA intervener if at the end of the proceedings there's a continuation of the review, new plans, new calculations to indicate what the experts believe should be revised to create a final plan. There was no final plan here. At the end of the proceedings, our intervener was completely shut out from that proposal. She did ask that the commission not do that. The commission could have asked the applicant to withdraw and finish up the work and get everything before the commission so that she could rebut and comment as she was entitled to. And this was a intervener that hired 2 engineers. She wasn't so much trying to oppose the application as making sure that this application protected the wetlands. She's a sincere, she had sat on the commission for 10 years. She knew what she was doing. She was very much trying to protect the wetlands in this decision. So I
do have a question for you, Attorney McTaggart, about
yes, Your Honor.
This argument about not having input at the end, when there were conditions that were put on the approval. Is that correct?
Yes, there were.
Were they specific conditions or more general, you need to address an issue much like the conditions in Finley?
They were both specific and general. It required resolution of inconsistencies, resolution of conflicts, and it required a new set of plans. It required calculations to look at. The pond reports were completely missing at the end of this, and the pond reports for this kind of an application with these kind of ponds was critical to know whether it could function. So there were specific requirements for outlet structures and so forth that had to do with those wet ponds. There also was a general requirement that these inconsistencies be resolved and that new plans be created, and that those then would be again reviewed by an expert to determine if they were efficient and appropriate. So there was a lot happening after the hearing.
Okay. All right. Thank you. You'll have 5 minutes for rebuttal.
Attorney
Sherwood, you have 12 minutes.
Thank you, Your Honor. May it please the court. Attorney David Sherwood, representing 101 Wickham Road, LLC. At the outset, I'd like to ask the court to keep in mind some critical facts. These are all from our statement of facts. in our brief, pages 2 through 15. The wetlands disturbance at issue here is 0.04 of an acre. That's 174 square feet. And no disturbance at all is proposed to the watercourse property. So the direct impacts of this proposal are truly minimal. The prior permit was issued in 2008, as you know, it was amended 9 times as recently as June 14, 2017. And the only change in the regulated activity since the June 2017 approval was the addition of 10 cubic yards in an upland review area outside of the wetlands. Yes, Your Honor.
Attorney Sherwood, in the briefs, when there's a discussion about whether there's a substantial change, it's unclear to me what the current application is being compared to, because there's sometimes a reference to 2008, sometimes there's a reference to 2012. You just made a reference to 2017. So when the commission is looking at whether there's a substantial change, what did they compare this application to?
Your Honor, I think the answer to that question is the 2008 permit as amended through the last amendment, because the commission, the initial approval in 2008 was a plenary review. Attorney McTaggart correctly points out that there was a finding that there was a potential significant impact.
You have frozen, Attorney Sherwood.
And couldn't have been issued.
Go ahead, you froze for a second, so.
I apologize, Your Honor. There couldn't have been a permit issued in 2008 if there hadn't been a finding that the regulated activities would not result in a significant impact. The permit was modified in various respects through 2017. I think what the commission was looking at was whether there were any significant differences between their last approval of the permit as amended and the current application. So
there's some discussion by the appellant about the Pala House project, and they say that was the one that was least impactful on the environment, as I understand their argument. And was that the 2017 proposal?
No, it was not, Your Honor. That was a proposed prior amendment which was not utilized.
So what amendment prior to the proposal that is before us had the greatest impact on the greatest potential impact on the wetlands?
The answer, I don't know the answer to that, Your Honor, but I can tell you that as of 2017, the direct impacts had been reduced to 0.04 of an acre of wetlands.
But the runoff, the indirect impacts, because you would agree that if the runoff had an indirect impact, that would be appropriate to consider, correct?
Certainly, Your Honor. And the commission did consider that. It considered, the commission considered that in issuing the 2008 permit and in all subsequent amendments, none of which were appealed by the plaintiffs. And a application proposing relatively minor changes to the permit, to the last permit as expired, was presented to the commission. The minor changes were all in relation to some adjustments that had been required by the fire marshal. And the commission initially, as the plaintiffs point out, at the initial meeting at which this application was considered, the commission was contemplating approving this without a public hearing, but the plaintiffs and additional citizens of Washington petitioned for a public hearing. So public hearing was held, and at that point, from that point onward, there was a absolutely comprehensive review of all aspects of this application that the plaintiffs wished to have reviewed. There was, the plaintiff had 3 experts. The experts participated in, some of the experts had participated in the prior proceedings on this, on the expired permit. They attended an on-site walk. They had access to all of the prior permit files, participated in all 5 public hearing sessions, and they submitted a total of 11 reports to the commission. So the plaintiffs fully participated in these proceedings. The commission, concerned about what the plaintiffs had introduced and the evidence that they had brought forth, engaged their expert, Land Tech, to review the application and the information that the plaintiffs had brought forth. Land Tech had visited the site previously on 6 separate occasions. They'd reviewed the proposed development on 13 prior occasions, produced 13 letters about this property and the prior permit. They produced 2 additional letters as a result of this application for a total of 15. And they found the changes from the 2012 permit, which was the, as amended, which was the last permit that Land Tech had reviewed, to the present, to be minor in nature. So I think, as I indicated, I don't know what variant of this proposal resulted in less impact. I think in order to determine that, you have to look at the commission's approvals, and the approvals all determine that the impact would not be significant.
Do you agree that because the commission determined that the impact would not be significant, that it never considered reasonable and prudent alternatives?
I agree that the commission was not obligated to consider reasonable and prudent alternatives, but the applicant proposed or discussed one alternative in its application, the alternative of leaving the property, leaving the layout of the property as it was, and the plaintiffs throughout the 5 public hearing sessions raised a number of what they considered to be alternatives to the proposal. But in the absence of any evidence of significant impact, the alternatives analysis isn't required to be undertaken by the commission. And the commission looked at this very carefully. This isn't a case where the permit, an application to renew a prior permit came in and the commission summarily approved it. This is an application which was looked at 7 ways from Sunday by 3 experts for the plaintiff, by the engineering firm of the applicant, and by the environmental consultants of the commission, plus the commission, 4 members of which had sat on all of the prior permits. Does that answer your question, Your Honor?
Yes, I guess the follow-up question I have is under 22A 42B, I think it is, it says that if there's a hearing because there may be an impact, then the commission has to consider feasible and prudent alternatives. And it seems to me that the commission concluded didn't look at may there be an impact. They just said, because there isn't an impact, we're not going to consider the feasible and prudent alternatives. And the statute to me seems to have different language in it. Can you address that?
I'm sorry.
Go ahead.
Again, at the initial meeting at which the application was received, there was some discussion based on the changes that were being proposed to the prior permit, to the expired permit, which was a few cubic yards of fill in an upland review area. There was discussion with respect to approving the permit without holding a public hearing. But a public hearing was triggered by the petition, and following the public hearing, Your Honor, there was extensive, wide-ranging discussion of every aspect of this application. We have a record of over 1,000 pages. The plaintiff and her experts, or the plaintiffs and their experts, dominated the proceedings. The commission listened to every piece of testimony, and at the meeting at which the vote was taken on the approval, the August 2018 meeting, the commission considered and discussed all of the evidence before voting. So it initially, the answer is yes, I think it's correct that they had determined based on what was presented by the applicant that the impact was negligible. Once the petition was filed and the plaintiffs participated in the hearing, they looked at all of the evidence presented by the plaintiffs, considered by their engineer, and presented by the applicant. If there are no other questions, I'll cede the balance of my time to my colleague.
Okay. Attorney Olson, that will give you 9 minutes to argue.
Thank
Your
you.
Honor.
Thank you, Mr. Chief Judge. May it please the court. Carrie Olson of the law firm of Murtha Kleina, representing the Town of Washington Inland Wetlands and Watercourses Commission. I intend to address 2 points raised by the plaintiffs in this appeal: the so-called impotent to reverse rule and the allegations of fundamental fairness in the proceedings. As this court is aware, the impotent to reverse rule says that administrative agencies are impotent to reverse themselves unless they find either a change of condition has occurred since their prior decision, or there are other considerations materially affecting the merits of the subject matter that have intervened and no vested rights have arisen. As the cases cited in our brief evidence, this rule has been repeatedly applied in the context of a reapplication. And to Judge Elgo's point, we believe that the Bradley case is directly on point here. And again, the tenets in that case where there was an expired permit, and still this court stated that they were impotent, they would be impotent to reverse themselves absent a finding of a change in circumstances. Yes, Your Honor.
The question I have, though, is it doesn't appear to me that the issue of the fact that this was an expired permit and the question here as to whether or not de novo review was required. I mean, I understand that the impotent, that language was applied here, but it doesn't seem like it was squarely addressed. Is there? It just seems like it was assumed that that was the standard, and I'm just not sure that Bradley squarely addresses this issue.
Where the permit has expired?
Correct.
I think it does.
Okay. All right.
Yep. The Bradley case says that the first thing you have to look at is, was there a substantial change? You have to look at either a substantial change or intervening events with no vested rights. Those are the only two scenarios under which, based on the Bradley decision, a commission can go back and rehash prior decisions made on a substantially similar permit. Now, in this case, again, what the plaintiffs argue is that a reapplication automatically opens the door for the commission to go back and rehash those decisions that were previously made. But the Fiorilla case states that it is for the commission in the first instance to determine whether the requested relief in both applications is substantially the same. This commission understood fully that its obligation in the first instance was to look at all of the information in the record that was supplied by the plaintiffs, as well as the expert opinions and their own experts' opinions, and determine in the first instance whether there was a substantial change. Yes, Mr. Chief Judge.
I'm going to ask you the same question I asked Attorney Sherwood. Substantial change from what?
Again, Your Honor, I would agree with my colleague that the last full review of the application was as modified was from 2008 up through and including the 2017. Again, this site has been gone over with a fine-tooth comb. I have the dubious honor of having been involved from the get-go. And
so
each
let
and
me
every one
just,
of these-
so
Yes.
here's what I'm trying to figure out. We have to determine whether there was, let's assume for a moment that we apply the substantial change test.
Mhm.
We have to determine whether there is substantial evidence in the record that supports the commission's determination that there was not a substantial change. In making that determination, should we compare the 2017 plan to the 2018 application?
So, Your Honor, but as the application evolves, with each modification, all of the preceding decisions of the commission become a part of and are incorporated into each of those modifications. So, for example, if there's a minor modification in 2017, that doesn't change the commission's decision. Again, if it's a minor modification that doesn't justify a reapplication or a new application, it incorporates by reference all that came before it.
All right, so let me ask specifically, what's the difference in the stormwater ponds between the current application and the previous applications?
Your Honor, as found by our expert, and to the best of my knowledge, from the last approval, there was no change in the stormwater ponds, especially in the sense of anything that would require to de novo review in this case. Again, the expert of the commission found clearly that this application was nearly identical to the previously approved permit with some minor revisions. And Land Tech found that those minor revisions had no impact, zero impact on wetlands and watercourses, which is within the jurisdiction of this commission.
So let me have two other questions for you. One of them relates to the approvals, and this maybe goes to the fairness piece that you were going to address. My understanding is that there are conditions on this approval. Is that correct?
Yes, Your Honor.
So are these specific conditions, or are they general ones like in the Stu Leonard case?
So, Your Honor, it's our position that these are the commission's general conditions. You might notice if you look at the transcript from the very first meeting, the general conditions imposed by this commission were discussed at the outset. It was based upon the petition that was filed that this went to a public hearing process. And so those conditions were discussed right from the outset. I would also point out, Your Honor, that, in this instance, what the plaintiff's complaint really is that it was fundamentally unfair for them not to have the last word. Again, the Land Tech letter.
Well, Bradley, which you cite, says that the party should have the opportunity to cross-examine the witness. They didn't get that opportunity here.
That's not exactly correct, Your Honor. So at that last hearing, when it was the plaintiff who submitted 2 new reports in the 11th hour, Mr. Allen was there. The issue was that Mr. Allen felt that some of the questions presented by the plaintiff's experts, again, at the 11th hour, required further review by not only him, but another member of his firm that was qualified. This court and the Supreme Court has made clear that commissions have the right to consult staff and their consultants after the close of public hearing. What the plaintiff's proposition would do is essentially reward parties to hide the ball until the last minute and then submit new information, tying the hands of the commission. It would put them in a quandary, Your Honor. They would either have to disregard the information, which this commission could have done based on its regulations, or they have to try to work through it without technical assistance. That should not be a satisfactory result, either for the plaintiffs or for this court. Fundamental fairness does not require the last word. As you might imagine, somebody has to have the last word. And if having the last word suddenly becomes the standard, you can imagine that it would open up the door for all kinds of fairness claims by anyone who did not receive the opportunity to have the last word. These hearings have to close by statute, Your Honor. Again, the submissions that were presented by the plaintiff were at the last minute, the 11th hour, without any time for the commission to have expert review. Thank you.
All right. Thank you, Attorney Olson. Attorney McTaggart, you'll have 5 minutes.
Thank you, Your Honor. First of all, the last application that had a full set of plans that was approved was not 2017. 2017 was one sheet that changed some retaining walls. The 2014-2015 Pally House plan had 30 to 32 sheets. It was a complete application. It included everything and was approved. All through this proceeding, there has been an attempt to ignore that application because, in fact, that application did provide 11.7% less impervious surfaces and development near the western wetlands. It was an improved application that was described as a, quote, vast improvement. So that was the last application. To answer your question about the one that had the greatest impact was the 2012 application, because the 2012 application by that time, through all these various incremental modifications, had completely eliminated all the pervious surfaces that were used for infiltration and to protect the thermal impacts on the river, and had increased the pervious surfaces to up to what is almost there now and is now 110,000 square feet of pervious surface.
Judge Elgo?
Counsel,
Yes,
could
Ronnie.
you just advise me as to these subsequent applications post 2008? Just could you advise us to what kind of hearing process, notice and hearing process is available for those subsequent applications?
Yeah, in some of some of them were done administratively. They were sign-offs as modifications administratively without hearings. There were hearings in the 2011 and 2010 applications, and one of those, by the way, did go to court. So to say that there was no court proceeding, there was a court proceeding.
There's
yeah.
notice for all of these.
Right.
For all these applications. Okay.
Exactly. And we actually did outline each of those in our brief. They are not identical, but one by one, those applications changed. Buildings were removed. There was another court case that affected a conservation area on this property, which was about 3 acres. And that 3 acres had buildings on it in the earlier plans. And then after a Supreme Court decision, it was determined there was a conservation restriction that would be upheld. So the buildings came off of those plans. But when those buildings came off, other buildings were made larger and changed. So there were a number of changes in what was going on in these applications. The hard thing to understand is how, if in 2008, a very protective application was approved as a significant activity, how now in 2018, the commission could do this. The other thing I'd like to say is the commission did not apply there may have been a lot of information, but their standard of review was to look only at changes. And at the very beginning of the proceeding, the chairman says, this was a decided permit. We're only going to look at changes. So no matter what was presented, each time there was a filter put on what was presented. And indeed, that filter went all the way through.
So, Attorney McTaggart, on the 2012 application,
Yes.
Were there hearings on that?
There wasn't a hearing on the 2012 that became what is called the Wickham project, which is used for these plans. There was no hearing.
Did your client seek to intervene in 2012 proceeding?
No, those proceedings were done in conjunction with settlements that were happening with a zoning lawsuit. And so where there were changes in the zoning plans to come back to the commission, those were routed through the Wetlands Commission and approved. And actually, Land Tech did review that plan and reviewed it as a university plan, not as an inn. So the answer is that that application did not have a public hearing.
Okay.
The other thing I'd like to mention is that the record here is not everything that's in the boxes in the town hall. The record is what was put into the record. There was a decision made during this proceeding that the applicant should figure out what they wanted the commission to look at and provide that information. It was not just what was there. The other just a moment.
Well, your time is up. So.
Okay. Thank you, Your Honor.
All right. I want to thank you all for participating in the virtual courtroom. We will take the matter under advisement and we will stand in recess until 11:30. Thank you all. Have a good day.
Thank you, Your Honor.
Thank you. Good morning.